Welcome to the Special Education News Roundup. This is Jennifer Price, Principal Attorney of the Law Office of Jennifer O. Price. Okay, so I know most people don't live in a school district where there is open enrollment. As a former resident of the state of Minnesota, I'm very familiar with open enrollment. Even though this case stems from Wisconsin and deals with some of the issues of open enrollment and students with disabilities, listen to why this case would still be applicable for any transfer student. All right, typically the school district in which a special needs student resides must satisfy the IEP requirements unless the student transfers to another school district. Wisconsin's open enrollment program permits such a transfer. The program operates on the calendar, and in January, school districts determine how many excess spaces are available in both regular education classrooms and special education services. So regular education spaces are typically determined by the grade level, while special education spaces are determined based on the program or the services. Now, between February and April, interested students may submit a transfer application to up to 3 non-resident districts. And for applications with IEPs, those non-resident districts determine whether they have the capacity to meet each student's special needs with the various list of relevant factors. Now, 3 students with special needs applied, and all 3 were denied acceptance into a school district that was not their home school. Those students filed a lawsuit complaining that their applications were rejected and claiming that this was a violation of the ADA, the Rehabilitation Act, and the Equal Protection Clause. The plaintiffs argued that the program discriminates against disabled students because it imposed criteria that apply only to students with special needs. However, the court thought that this was a mischaracterization of federal law and the program itself. You see, under federal law, a program is not discriminatory just because it takes an individual's disability into account. And quoting the court, he said, although a disability is not a permissible ground for assuming an inability to function in a particular context, the disability is not thrown out when considering if the person is qualified. In other words, federal law forbids discrimination based on stereotypes about a handicapped, but it does not forbid decisions based on the actual attributes of the handicap. And under the open enrollment program in Wisconsin, non-resident districts cannot turn away applicants merely because they are disabled. But the program does allow non-resident districts to realistically assess whether they have the capacity and resources to comply with the transfer student's IEP. So according to the court, these decisions are based on the actual attributes of that handicap, not the stereotypes of that handicap. And then when it came to whether they violated the ADA or the Rehabilitation Act, the court emphasized that neither the ADA nor the Rehab Act requires modifications that would fundamentally alter the nature of the service program or activity. These are things that should be considered when you're thinking about transferring. Okay, this case was about open enrollment in an open enrollment school district, but this really can be applied to any school district. I live in Pennsylvania. There is no open enrollment, and there are school districts that have been known to not accept special needs students simply because they didn't know if they could fulfill the obligations of the IEP. So once again, I understand that this case involves open enrollment, but school districts look at an IEP for a transfer student, or at least request to look at the IEP for a transfer student before they will give a parent an acceptance of that student first. So think about that when you are thinking about whether the student is, or the school district is, denying your student access to their school because of the disability, or is the school really saying that because they don't know if they can truly address the needs of the IEP. And then the other thing to think about is, do you really want your child going to that school if the school district really is concerned about whether they can appropriately address your child's needs in the IEP? And is your child really going to have an appropriate education at that school if the school district is already questioning whether they can appropriately address his or her needs according to the IEP? Thank you for listening.